care of your food for thought. We also take care of your food for stomach. You should be happy. I started 1 minute earlier just to briefly tell you what's happening in MMA next 2-3 programs, which I do not want any of our members to miss it. I'm audible there wrong? Yes, good. Let me tell you what's happening on 30th of April. This is a program which is discussed widely in the Supreme Court, and so many instructions were given. I don't take the name of the organization. The subject is ad was making competition healthier. And we really wanted our members to really understand what ad means. And so much of social media publication we do in Instagram, social media, Facebook. So we want to be very careful. We got a very good panel to come and share their thoughts. Manisha Kapoor, she is the CEO of and Secretary General of the Advertising Standards Council of India. That's a watchdog which really oversees what's happening in all the ad industry. We got Ilango, is from Draft Ulka, PCB Ulka. Then Shashank Singh is the head of marketing from India Cements Limited. And we also have Mr. Nag is from partner RK Swami Answer Group. So this is a good one. It's especially for young business people and who really use it's better to avoid, and it's always better to under promise and over deliver. You know how the people are in deep trouble with the court. So let's not do that. You come and attend this program on 30th. Then on 7th of June, again, we have an interesting subject which is relevant to all our members. Opportunities, challenges and opportunities in resilience and infrastructure, financial sector and respect of cyber security. We have Ansraj Verma, IAS Additional Chief Secretary, also the MD of TIS. We got Vittal Raj, he is a founder, he is a member of International ISACA US, and very knowledgeable person. We also have Commander Prakash is a Senior Director of CDAC Chennai. This is happening on 7th of May at MMA Management Center. Then on 9th, we have again an interesting event because a lot of people wanted this. So many amendments have been brought about in the last few years regarding the real estate issues, and we want to know something is changed, something is different valuation, what is the guideline value. Totally not really clear. So we are getting a specialist with the panel. Aarti is a partner of Shardul Amarchand. She's going to be talking to on navigating changing emerging trends in real estate regulations and impact on the industry. We're also having partner Guerra. We'll have the best of the people we're planning to buy, or you want to advise some of your friends what you learn from MMA, come and attend this event. It's all happening at 6 o'clock, as usual, 6 to 7:30. Then on 15th of May, we have very, very interesting event. Again, I will really urge upon you not to miss this event. Electoral reforms is a bane or boon. Again, we have a very interesting panel. T.S. Krishnamurthy, former Chief Election Commissioner, is there. Trilotan Shastri. I'll actually walk miles to listen to Mr. Trilotan Shastri. He is a founder of Indian Institute of, he's a former Dean of Indian Institute of Management, Bangalore, and he's also chairman of ADI. ADI is all know, Association of Democratic Reforms. Based on their, I think, appeal and rule, the electoral bonds got suspended and much more. And you must listen to him what exactly is happening, whether it's good for the nation, it's not bad. We don't know. You listen to the expert, then you can take your call. On 22nd of May, we have Read and Grow on the subject. What got you here won't get you there. So again, we got a very good panel. I don't want to take the thing for the paucity of time. Then we have on Friday, 7th of June, Embrace the Future, Software Science and Business Transformation. And again, it's a very good speaker. We have R. Sheshai, former Managing Director. He's a chairman of Asia Paints now. Then along with him, we have Gopal Krishnan, former Executive Director of Hindustan Unilever. Then Irish Bhattacharya is an author, management consultant, teacher, and again, former senior VP of Unilever. This is only happening number of programs. I want to only tell you a few, which you, by any chance, you missed your inbox, you don't miss them. Coming to today's event, let me warmly welcome all the viewers watching this program live. Mali President MMA is supposed to be here, and unfortunately got stuck in the event and conveyed a sincere thing. He will join us any moment. And let me warmly welcome all the viewers watching this program live in all our channels. As usual, the number flashed on your screen. Please send your questions if you have any. And I only request you to, the focus of the question should be the topic what you are discussing. And keep sending them. We'll put them, and the panelists agreed to respond to all your questions. And today is a great day because when Jainil met me a couple of months back, you want to do, I know this is a subject which is very, very dear to many and which will add a lot of value to our members. That's why we decided to do it right away. And I took the decision to do it that way, and with the committee's support, it's a good decision I took because it's such a passionate team. We interact with quite a number of people and organizations. They're so passionate in doing things, and I mean, you're going to listen to the people next few minutes, their input, which will be very, very useful. We also given the program schedule where we given the QR codes of what you really need to know. It's the profile of the speakers, the slides. Every time you keep asking me, this entire slide deck is there available there. Then everything what you want to know a little bit about arbitration will be very, very useful to you. That's why I put in a QR code and given it to you. Now, today is really indeed privilege and great honor for MMA because let me have the privilege of welcoming Justice V. Ramasubramanian, former judge of Supreme Court of India and Madras High Court. And he joined us online from Delhi in spite of his very busy commitment. Very warm welcome to you, sir. It is indeed a privilege to have you with us this evening. And we are all eagerly looking forward to your thought-provoking and insightful keynote address. Very warm welcome to you, sir. And I also take this opportunity to welcome the distinguished panel for this evening. We have Jainil Bhandari, partner, Rajah Tann Singapore, then Avinash Pradhan, Ganesh Chandru, partner, Dua Associates, Srikanth Navale, she is independent arbitrator, Singapore and India, and Bala, deputy head of shipping and international trade, partner, Rajah Tann Singapore LLP. So we also have a lot of members, advocates, young advocates, people from law college. There are so many of them here, and I know so many of them confirm. I'm quite sure they'll be joining us any moment. It's indeed a pleasure to have you with us. I know this subject will give you a lot of insights. I firmly believe arbitration. You must know what is arbitration to do it at home. I keep doing this between my wife and my children. Every time there's a fight, we do the arbitration, settle it amicably. But when you're in business and you're going to learn some good techniques, wherever and whatever you do, the insight what you're going to gain today will be a stand you good in whatever you do. And as much as you, I'm also looking forward to eagerly listen. And before I move on further to call the panelists, let me also firmly tell you all the events what happened. I told you and question slips. They have also given a question slip to each one of you. If you have any questions, please answer your question to do that. Ladies and gentlemen, put your hand together to warmly welcome our distinguished panel for this evening. Justice Ramasubramanian joined us online from New Delhi. We have Jainil Bhandari, Avinash Pradhan, Ganesh Chandru, Srikanth, Navale, and Bala. May I repeat, please take a place for the dice. Ladies and gentlemen, a warm round of applause to our distinguished panel. Most of them come from Singapore only for you to share their insights. I mentioned about the format of the program. Our distinguished chief guest this evening will give a formal keynote address on the theme. Thereafter, panel discussion and Q&A. And before I call upon our distinguished chief guest for this evening, Justice retired Ramasubramanian, former judge and Supreme Court of India. Let me have the privilege of introducing him. And India is the boast of a distinguished legal career spanning over 23 years in High Court of Madras, graduating in chemistry from Ramakrishna Mission Vivekananda College, and later pursuing his law from Madras Law College. He was enrolled as a member of Bar in 1983 with the experts on the top practices in notable tenures. His journey exemplifies unwavering dedication to justice and rule of law. I can tell you, ladies and gentlemen, each one of you are here, each one of you are watching it online. You are blessed to be here this evening to listen to Justice Ramasubramanian. Now I request Justice Ramasubramanian, please deliver the keynote address. Over to you, sir. Justice Ramasubramanian.
Thank you, Group Captain Vijay Kumar. The President of the Madras Management Association, the other office bearers of MMA, the partners of Rajah Tann, respected speakers and panelists, distinguished invitees. A very good evening to all of you. At the outset, I apologize for my inability to be physically present. The pleasure of addressing an audience live is lost for me today. There is one more aspect. The opportunity to address an audience physically gives the sadistic pleasure of violating the human rights of a few, which I miss today. I do not know
Ladies and gentlemen, I think technology so good sometimes happens. Very rarely it happens. This happened today. But you'll be joining us any moment now. Till then, a lot of new people who have come for the first time. Let me tell you what's about MMA. MMA is established in 1956. We've got over 8,500 members. We do some 150 events in a year. And we have a great infrastructure which you are here today. We've got about 24,000 square foot. We've got phenomenal car parking, state-of-art library, and multiple classrooms. And you must come and use our library. We've got the library. We've got 1.25 million books which can be referred and used, research papers. We've got a lot of e-books. Besides that, we do a lot of unique programs, number of workshops, certificate courses, and many things. But one thing, we also do some training for IAS preliminary and IAS advanced courses. So that will be a full-fledged course we conduct. And one advantage of this, you do the course, I think you get also diploma in management. I think I've said maybe I'll request the distinguished panel. I'm taking time to introduce our panel. By the time Justice will join us, let me introduce the privilege of introducing Jainil Bhandari. Jainil Bhandari is a partner, Rajah Tann Singapore, and he's also a director of Rajah Tann Myanmar with legal experience since 1989. He specializes in shipping and trading disputes, international commodity contracts, and offshore construction projects. A qualified arbitrator and fellow of the Chartered Institute of Arbitrators. Jainil is also recognized as a global leader in shipping law and has been consistently ranked as chamber and the Legal 500 and other prestigious publications. We also have with us very warm welcome to Jainil. It's a pleasure and really appreciate your support to MMA in bringing this great event today. Then we also have Avinash Pradhan. Avinash Pradhan is the Deputy Head of International Arbitration and Company, Head of South Asia Desk and Rajah Tann Singapore LLP, and recognized for his advocacy, skill and expertise in international arbitration. He specializes in commercial disputes across sectors like banking, M&A, and construction. Avinash is accredited specialist in building and construction law and acknowledged by who is who and legal ALB, Asian Rising Star, and legal finder for his exceptional abilities. Let me have the privilege of introducing Ganesh Chandru, partner Duva Associates. Ganesh is a partner Duva Associates India, specialized in international and domestic arbitration, commercial litigation, and ADR. A fellow of the Chartered Institute of Arbitration UK and Singapore Institute of Arbitrators. He is appointed by the Government of India to be the India's International Arbitrator Center and has served as a counsel and assistant registrar of SIAC and recognized globally. Ganesh is listed as who is who legal arbitrators of 2024 and Forbes Legal Power of 2021 and his expertise in arbitration and mediation. Very warm welcome to you, Mr. Ganesh. Let me have the privilege to introduce another distinguished panelist for this evening is Srikanth Navale. Srikanth Navale is an independent arbitrator and also Singapore with Shimma ADR India. Specializing in ADR, he handles arbitrators across various sectors, including trade, service, aviation, and healthcare, and with a unique blend of legal, financial, business, and expertise. Srikanth is also a fellow of the Chartered Institute of Arbitrators and serves in the panel of ICAR, IA, and AICC. Very warm welcome to you, Mr. Navale. It's a pleasure to have you with us. We also have with us Mr. Bala. Bala is a Deputy Head of Shipping, International Trade Partner, Rajah Tann Singapore. Okay. Bala is the Deputy Head of Shipping and International Trade and partner of Rajah Tann Singapore. Trained as a marine engineer, he specializes in shipping, energy, offshore, international trade disputes, recognized by the best lawyers as Asia Law and is Chamber of Asia Pacific Bala is an accredited specialist in maritime and shipping law by Singapore Academy of Law and speaks on global conferences across in all international conferences. Ladies and gentlemen, yeah, once again, a very warm round of applause for distinguished, really, really outstanding panel this evening. I will now kill our, I think Justice will be joining us any moment. There's some power issue in Delhi. I think election is happening, so there has to be a power issue. And I request.
I have joined. I have joined.
Oh, Justice joined. So, over to you, sir.
I'm so sorry.
No, sir, no issue, sir. It's perfectly okay.
I'm so sorry. Actually, Delhi is a place, according to me, of power and pollution. So whether there is pollution cut or not, there is always power cut in Delhi. And I do not know whether to thank the organizers or not for inviting me to deliver the keynote address before the special session. The special session, as all of you know, is on arbitration, the nuts and bolts, and I do not know under which category they have placed me. To begin with, I must congratulate the Madras Management Association for joining hands with Rajah Tann of Singapore for hosting an event of this nature in Chennai. As a lawyer who practiced entirely in Chennai, and as a person who spent 10 years of my judicial career in Madras High Court, I was always flabbergasted by one paradox, and it is this. Tamil Nadu has always been one of the favored destinations of foreign investments. Therefore, one would have expected Chennai to be one of the top destinations for arbitrations also. But ironically, while the flight of capital is towards southern part of India, the flight of arbitration is towards north of India. Therefore, I am glad that the MMA thought fit to bring one of Asia's top law firms to Chennai. I do not know how many of you are aware of the fact that Rajah Tann are placed 19th among the world's best firms in the field of cross-border restructuring and insolvency work. And for the 6th consecutive time, they featured in Global Restructuring Review's prestigious top 30 list of standout firms. It was highlighted in Global Restructuring Review that Rajah Tann's winning streak continued from 2018 in GRR 30. In fact, the current Chief Justice of the Supreme Court of Singapore was the managing partner of Rajah Tann. Therefore, MMA has done well to join hands with them for hosting this seminar. Like Rajah Tann, MMA also has a glorious past. Established in 1956, MMA is one of India's foremost management associations, winning the Best Local Management Association Award continuously for the past 12 years. They also deserve our appreciation for this initiative. Dear friends, today India has become one of the fastest growing economies in the world. The IMF Executive Director was quoted by CNBC on March 1, 2024 as saying, I quote, "If you look at the GDP numbers, India is poised for about 8% growth this year. That makes India easily the fastest growing economy in the world. You look at the statistics regarding capital flow into India, especially since 1991 shows that the economy has grown by leaps and bounds. Total FDI inflows into the country from April 2000 to December 2023 was $971.521 billion. Out of this, the total FDI inflows received from April 2014 to December 2023 constituted about $448 billion US. Mauritius constitutes 26%, Singapore contributes 23%, USA 9%, Netherlands 7%, and Japan 6%. All these countries emerged as top 5 countries for FDI equity inflows into India for the year 2023-24. History shows that many times the flow of capital is followed either by aggression or by litigation. India is no exception to this general rule. After our economy opened up in 1991, India entered into a series of bilateral investment treaties. By the year 2015, India had signed 83 BITs and several international investment agreements. The first ever BIT was with the United Kingdom in 1994. In the year 2003, India developed its own model BIT. The first 10 years from 1994 to 2004 perhaps proved to be a period of honeymoon between the Republic of India and the investors. But the honeymoon ended in 2004 with the initiation of the first round of BIT arbitration in 2004 in the Dabhol power plant case. Planned as a joint venture between the Maharashtra Power Development Corporation, Enron, General Electric, and Bechtel, Dabhol Power Corporation aimed to set up a huge naphtha-based plant in the first phase and another huge gas-based plant in the second phase. As the largest foreign investment in the country at that time, Enron was given top priority in terms of clearances. But the power purchase agreement between Enron and the Maharashtra State Electricity Board was kept under the wraps. Therefore, the party in opposition at that time promised to throw the project into the Arabian Sea once they came to power. When they came to power, it was revealed that Maharashtra State Electricity Utility was paying 7 rupees 80 paise per unit to buy power from Enron, while charging retail consumers 1 rupee 89 paise per unit. By contrast, the cost of power purchased from the other producers like the National Thermal Power Corporation and the Bombay Suburban Electric Supply varied from 80 paise to 3 rupees per unit, in contrast to 7 rupee 80 paise per unit being paid to Enron. Therefore, this created a huge furore. At around the same time, something was happening in the US. Enron was found guilty of a huge accounting and corporate fraud. Therefore, it went into bankruptcy. The agreement was terminated. However, the other investors like Bechtel and the General Electric brought claims against India under the India-Mauritius BIT, alleging expropriation of their interest in the power plant by the Indian government. The claims were, however, settled, and India had to compensate for the losses. After Dabhol came the second most important BIT arbitration case involving the Australian company White Industries. In 1989, the Australian company entered into a contract with Coal India Limited. Though the contract was governed by Indian law, the contract specifically excluded the operation of the Indian Arbitration Act 1940, which was the law at that time. But it contained an arbitration clause requiring the parties to arbitrate all disputes under the ICC arbitration rules. Therefore, when the disputes arose, they were referred to an ICC tribunal in June 1999. An award was passed in 2002. The award was challenged before the Calcutta High Court. The Australian company filed an application before the Delhi High Court to enforce the award. The Australian company moved an application first for transfer of the Section 34 petition from the Calcutta High Court to the Delhi High Court. Thereafter, they moved the Calcutta High Court itself for rejection of the application to set aside the award. The Calcutta High Court dismissed the application for rejection of the petition under Section 34. The division bench confirmed it. The Australian company filed an appeal in the Supreme Court. The appeal was referred in the year 2002 to a larger bench. 9 years passed. Therefore, in the year 2009, contending that the inability of the Indian courts to enforce an award for a period of almost 7 to 9 years, tantamount to a breach of Articles 3, 4, 7, and 9 of the BIT, the Australian company launched a claim for a sum of Australian dollars 10 million upon the Republic of India. As there was no response from the Indian government, the Australian company invoked Article 12, which provided for the reference of the dispute to an ad hoc tribunal constituted under the arbitration rules of UNCITRAL. Before the arbitral tribunal, the Australian company advanced two arguments. One related to the violation of what is known as FET, Fair and Equitable Treatment Clause, under Article 3, Subclause 2. It was contended by the Australian company that the entertainment by an Indian court of an application to set aside the award and the shocking delay on the part of the Indian courts in dealing with the application for enforcement of the award amounted to denial of justice, and as a consequence, it violated the FET standard, Fair and Equitable Treatment Standard. The second important contention of the Australian company was that the Indian court's delay of 9 years in enabling them to enforce an international arbitration award was directly attributable to the failure of the country to provide effective means of asserting and enforcing the rights under the award, and that therefore it constituted a breach of Article 4.2 of the BIT. Interestingly, Article 4.2 of the BIT between India and Australia did not contain a clause for the provision of effective means of asserting claims and the enforcement of rights. But the Australian company drew parallel from Article 4.5 of the agreement between the Republic of India and the state of Kuwait, and contended that there was an obligation on the part of the Republic of India to treat investments made in its territory on a basis no less favorable than those accorded to investments of investors of any third country. In other words, they claimed that the investments of all countries deserved equal treatment. Interestingly, the arbitral tribunal rejected the claim of breach of Article 3.2, that is FET standard, which revolved around the failure of the Indian courts to dispose of the matter. But the tribunal upheld the contention revolving around Article 4.2, and the tribunal said, I quote, Indian judicial system's inability to deal with white industries' jurisdictional claim in over 9 years and the Supreme Court's inability to hear white industries' jurisdictional appeal for over 5 years amounts to undue delay and constitutes a breach of India's voluntarily assumed obligation of providing white industries with effective means of asserting claims and enforcing rights. After this white industries case, there has been several BIT arbitrations involving the Republic of India, such as Louis Dreyfus Armatures. Then this was under the India-France BIT. Then Deutsche Telekom versus Republic of India under the India-Germany BIT. Kadamat Integrated Solutions Private Limited versus Kingdom of Saudi Arabia under the India-Saudi Arabia Treaty, etc. Then came the Vodafone arbitration case. It became a classic case for the nuances that it threw up. The original arbitration was under the India-Netherlands Treaty. While the arbitration was pending, Vodafone filed another investment arbitration under the India-UK BIT against the retrospective effect of an amendment made by the Indian government under Section 9(1) and Section 195 of the Income Tax Act 1961, read with Section 119 of the Finance Act 2012. The Indian government approached the Delhi High Court seeking an anti-arbitration injunction against Vodafone for initiating two parallel arbitral proceedings, one under the India-Netherlands Treaty and another under the India-UK Treaty. But in the year 2018, the Delhi High Court rejected the contentions of the Republic of India, upholding the principle of competence, and held that the purview of intervention with the BIT arbitration is very limited, and the provisions of the Arbitration Act will not apply to BIT arbitrations. The year 2019 also saw some relevant investor-state disputes. Keytan Holdings Mauritius issued a notice of dispute to the Republic of India under the India-Mauritius BIT. Republic of India moved before the Delhi High Court seeking an anti-arbitration injunction, but the Delhi High Court, relying upon Vodafone, rejected the application for injunctions. Another interesting set of investment arbitrations took place in Nissan Motor Company case, where fair and equitable treatment clause came to be evaluated by the Permanent Court of Arbitration, Singapore. The arbitration was under the India-Japan Economic Partnership Agreement against the non-payment of unpaid incentives under the Indian tax regime. Republic of India's objection to the jurisdiction of the PCA Singapore was eventually rejected. The fallout of these spate of arbitrations, actually as of 2015, there were about 17 known BIT claims against India. So the fallout of these spate of arbitrations was an increased national concern. Therefore, between 2012 and 2016, India revisited its BIT regime, which led to two main outcomes. The first was the adoption of a new model BIT in December 2015, with the twin objects of affording, one, appropriate protection to foreign investors in India, and number two, while maintaining a balance between investors' rights and the government's obligations. The objective was to terminate the old BITs where initial duration had concluded, or the issuance of joint interpretative notes statements for renegotiation on the basis of the model BIT, where the BIT's initial term was still in continuance. Since 2016, India has terminated 77 bilateral investment treaties. It has entered into several new generation BITs with states such as Belarus, Brazil, Taiwan, Kyrgyzstan, etc. In May 2022, India entered into a Comprehensive Economic Partnership Agreement, CEPA, with the United Arab Emirates and India-Australia Economic Cooperation for Trade Agreement, ECTA, with Australia on 29th December 2022. The Model BIT 2016, as we know it now, consisted of 38 articles and 7 chapters. It seeks to enhance the bargaining power of the state. The Model BIT has adopted what is called the Salini criteria, as was held in a landmark case between Salini and the Kingdom of Morocco. This Salini test is a test employed by tribunals to define the term investment in Article 25(1) of ICSID Convention. To pass this Salini test, the investment should satisfy 4 criteria, namely 1, a contribution, number 2, a certain duration, number 3, a risk, number 4, a contribution to the economic development of the host state. The model BIT has made an exclusion of pre-investment activities from the purview of investments and has removed the MFN clause, most favored nation clause. Another clause which has come under criticism is Article 15.2 of the model BIT, which requires that an investor has to necessarily seek legal remedy from the domestic courts of a host state for an initial period of 5 years before seeking a claim under the model BIT. Model BIT 2016 has also evolved a differentiation between direct and indirect expropriation. Dear friends, India's model BIT came under serious criticism on the ground that it is host state centric. Some critics have said that after India's actions post 2016, the flow of FDI into India has declined. But there are others who say that it has not. In the budget speech of 2024-25, the Union Finance Minister said, I quote, the FDI inflow during 2014-23 was $596 billion, which is twice the inflow during 2005 to 2014. I unquote. Interestingly, the finance minister gave a different connotation to the acronym FDI. We all think FDI is foreign direct investment. The finance minister said in her budget speech that the acronym FDI should henceforth stand for First Develop India. That should be FDI, is what the finance minister said. Dear friends, there are 3 areas which continue to pose serious challenges to the BIT arbitration regime. They are public health, human rights, and environment. When arbitral awards touch a raw nerve on these 3 areas, there is a big hue and cry that these are instruments of domination by the powerful against the democratic will of the people, which leads to unacceptable discrimination between nationals and aliens, blackmailing of governments by multinationals, and the protection of polluting industries causing harm to environment. This is the theory that is advanced by the opponents of this regime insofar as the areas of public health and environment are concerned. Therefore, the investors, the lawyers in the arbitration circuit, and the arbitrators have a duty to strike a balance. I do not know how many of you have heard about Mr. Samuel Gompers, a Jewish immigrant trade union leader. He founded the American Federation of Labor. Of course, in the context of mandatory arbitration clauses in employment contracts, Samuel Gompers said something very interesting. It goes as follows. He said, do I believe in arbitration? Yes, I do. But not in the arbitration between the lion and the lamb, in which the lamb is in the morning found inside the lion. I unquote. Though he said it in the context of arbitration between workers and managements, the same should not be allowed to be said of investment arbitrations also. Therefore, with these few words, I take pleasure in welcoming Rajah Tann and MMDA for organizing the seminar on a topic of seminal importance. I hope the participants will hugely benefit from the knowledge that is shared by persons carrying a lot of expertise in this field. Thank you very much.
Thank you, Justice, for inspiring and thought-provoking address. I'm sure you'll be staying here for some time. It'll be a nice thing. And ladies and gentlemen, a warm round for Justice for delivering a keynote address with the tone for the discussion to come. Now, I request Avinash Srikanth to take it forward. You will be moderating. Jainil, please. Yeah, special session. Mr. Jainil.
Thank you. Yeah. Justice Ramasubramanian, Captain Vijay Kumar, distinguished guests, a very good evening to all of you. And thank you very much for taking the time to come today for this event that we have organized together with the MMA. And in today's event, we have actually put together a short presentation and a panel discussion about why international arbitration is the preferred mode of dispute resolution for cross-border disputes. So we take the position in this event that where you have cross-border disputes, that is meaning where you have an Indian party that is involved in a dispute with an overseas party, instead of litigating it in court, whether it's the Indian court or the courts of the overseas country, you should instead go for arbitration. And today we will explore why that is the preferred option by just giving you some key basic concepts, some key pieces of information which you can take away, and hopefully you are then convinced that you should put arbitration clauses in your commercial contracts instead of litigating in court. So today, there are 4 areas that we will deal with in the presentation, and then we'll have a panel discussion where we will delve more deeply into some interesting issues that arise in an arbitration and in the enforcement of an award. That is the culmination of the arbitration. And that will be followed by a Q&A session where you can raise any questions that you like, obviously concerning the topics that we have raised today, right? To the panel. Right. So we'll first start off with a brief introduction, and then we'll talk about key concepts and advantages of arbitration. And then we will deal with some key features of the SIAC rules or the SIAC rules. Some of you may be familiar with SIAC, which is Singapore, which is it's an arbitration institution in Singapore, the Singapore International Arbitration Center. And lastly, we will give you some tips on drafting an arbitration clause. Right. So let me just start off with a very basic question of what is arbitration? And essentially, it is a consensual dispute resolution process, which is based on the parties' agreement to submit their disputes for resolution to an arbitral tribunal. So it's actually a private hearing, and the foundation of the arbitration is the parties' agreement to refer the dispute, whether it's to one arbitrator or 3 arbitrators. So the process is based on an agreement, and the agreement, the arbitration agreement, must be in writing, and it is usually contained in the contract that is entered into between the parties. And the key feature in arbitration is that it's flexible. It is for the parties to agree on the form of procedure they wish to adopt. No specific rules of evidence apply. And this is actually something that the parties have adopted and agreed to adopt. So there is therefore that flexibility that's worked into it. And the result, which is extremely important to the parties, is the award. And in an arbitration, and we will explain why as we go along, the award itself is a final decision that is legally binding, and it cannot be easily unwound, whether by it's the court of receipt or the court of enforcement. That is the basic premise of an arbitration. Now, the process itself in an arbitration is similar to a court hearing in that there is a procedure for the parties to present their cases. And quite typically, the way the procedure works, both for court and arbitral process, is that you have initial documents that are filed, which sets out your case, which puts out your arguments, where you present your evidence. And then after that, there is an oral hearing where witnesses are called and cross-examined. And then there is closing submissions, and then you have an arbitration award. Now, in an arbitration process, typically, because of the flexibility, there are no rules of court that apply. And because of the flexibility, you can take two approaches. You can take either what we call the pleadings approach, which is similar to court proceedings, where parties put in case statements. You put in a claim statement where you set out the main facts relied on, you attach the documents to the claim statements, and then the other side puts in a defense, or if there's a counterclaim, puts in a counterclaim, then there is a reply and a defense to counterclaim, etc. And then the evidence comes later. So the evidence itself that you rely on, witness statements, experts' reports, etc., is not attached to the pleadings. So that is what we call the pleadings approach. But in an arbitration, you can also take a memorial approach, which is where the parties will set out their entire case, all your documents, all your legal submissions, all the evidence that you rely on, which means your factual witness statements, your experts' reports, everything is put into the documents that are initially filed. So when a claimant puts his memorial forward, he's putting out his entire case, which the defendant then looks at, or the respondent looks at, and then responds accordingly with his entire case. So the stages are sort of cut short. Now, you can argue which is the better method, right? Those that prefer the pleadings approach say that it's better for parties to put in the case stage by stage, so that we can then consider the case, and then we can, if we think that they have a stronger case, then we can, negotiate a settlement before before the costs run up too high. Because with a memorial approach, you have to kind of front load your case. You front load your costs because your entire case is put forward right at the start. So sometimes parties don't like that kind of approach. But again, it just illustrates the flexibility of an arbitral process. Now, why arbitration over court proceedings? Basically, three key reasons. First, arbitrations are generally a faster process. Because if it's governed by certain rules, for example, if it's the SIAC rules, once the hearing is concluded, the tribunal has to come up with an award within 3 months. And typically, because you don't have formal rules of evidence applicable, you don't have all these applications that come in, that kind of prolong the court proceedings, for example, the process moves very swiftly. And typically within 6 to 12 months of starting the arbitration, you can get an award. So that's one key benefit. Secondly, costs. There is greater recoverability of costs in an arbitration. When we talk of recoverability of costs, what we mean is that the winning party, whether it's in court or arbitral proceedings, will usually get an order of costs in its favor. But in court proceedings, most national courts, and this is true of Singapore, Malaysia, and I believe also in India, most national courts will not award the winning party 100% of the cost that it has incurred. So if you have incurred $100,000 to bring a case right to its conclusion, whether it's court proceedings or arbitration, you have incurred 100,000. The order for cost that you may get if you win from court may be 20%, 30%, 40% of 100,000. That's all you will get. But in an arbitration, you almost always recover your cost in full, unless it is shown to be very unreasonable. So that is one key advantage of arbitration over litigation, in that the successful party can recover almost all its legal costs in the award from the unsuccessful party. And lastly, it is, because it's a flexible procedure and it's a more informal procedure, it's not in front of a judge or in front of a courtroom. The process is simpler, more convenient for the parties, less intimidating for witnesses, and also the formal rules of evidence don't apply. What are the other advantages of arbitration? Why do parties want to arbitrate? There's privacy and confidentiality. Court hearings are open hearings. You go to open court, anybody can walk in, they can listen, reporters can come in, they can report the case in the press, right? So that is something that parties may not want. They want to preserve the confidentiality of their agreements, the confidentiality of the dispute. So they opt for arbitration because it's a private hearing. That's the first thing. Secondly, neutrality of the forum. You can choose your forum. You can decide, right, that if I'm contracting, say, with a Chinese counterparty or a Taiwanese counterparty, right, or a Emirati counterparty, let's say, I can decide whether I want to put the forum for the arbitration in, say, Singapore or Hong Kong or Dubai. The choice is mine, right? So the parties like that. Thirdly, as I mentioned, procedural flexibility that you have in arbitration. You're not bound by rules of court. There is a procedure, it is agreed, but it's less formal. Next, potential finality of an award. There is no appeal on the merits. You can only set it aside on very limited grounds. My colleague Avinash will expand on that course of this presentation, right? International enforcement, meaning to say, unlike a judgment which may not be recognized in a foreign court, an arbitration award, by virtue of the fact most countries have become signatories to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, it is enforceable in a convention country. So there are more than 100 over countries that have ratified the convention. And it simply means that if you contract with a counterparty who is from a convention country, an award that is obtained against that counterparty can be enforced in that country. Of course, there is a process that you need to go through, but it's a relatively simple process, and it is relatively easy to enforce the award as opposed to a judgment which may not even be recognized by the courts of that foreign country. So, international enforcement. And lastly, expertise. Why? When we say expertise, the arbitration process is favored by various sectors and industries simply because you can choose an arbitrator with the specialized knowledge that is required for that particular industry or sector. So when we look at contracts typically with arbitration clauses, they cover various diverse sectors. You will see it in manufacturing contracts, which are really usually cross-border contracts, right? So a lot of such contracts would have an arbitration clause. Secondly, you see arbitration clauses in technology contracts, because technology disputes are highly technical and complex. And in such contracts, if you have an arbitration clause, you can choose a tribunal who has the required knowledge to understand the dispute, to understand the issues, and to arrive at the correct decision. So you see that in technology contracts. Thirdly, very common to have arbitration clauses in logistics contracts and also in commodities contracts. Now, in commodities contracts, we're talking basically of sale and purchase of both hard and soft commodities. And you can have various kinds of disputes, quality disputes, quantity disputes, non-delivery, force majeure. And for a lot of these contracts, for many years, they have been subject to arbitration. And you have trade associations like GAFTA, FOSFA, FORA, which have their own rules of arbitration. So the parties are familiar with the process. They are familiar with the rules of arbitration, and they opt to put an arbitration clause in their contracts. And lastly, where it is very common to have arbitration is in shipping or maritime contracts. Now, again, because shipping is multi-jurisdictional, you will see arbitration clauses invariably in various types of shipping contracts. For example, charter parties, contracts of affreightment, sale and purchase, ship sale and purchase agreements, shipbuilding contracts, ship repair contracts, etc. And this has also been the position for many, many years. And for a lot of these shipping-based contracts for a long time, most of them provided for London arbitration. And London arbitration under the rules of the London Maritime Arbitration Association. But that has changed over the last 10, 15 years. We've seen a shift of disputes coming towards Singapore, Hong Kong, and lately, Singapore has already surpassed Hong Kong in terms of the number of disputes that have come in. And so for maritime arbitration, we have a Singapore Chamber of Maritime Arbitration in Singapore, which is an arbitration institution that was established specifically to serve the maritime community. So it was actually set up after taking feedback from various shipping industry players. And the feedback that was received was that the shipping industry preferred to have a simpler way of resolving disputes as opposed to a typical institutional arbitration where you have the institution like, for example, ICC or LCIA or SIAC, where they actually play an active role in the administration of the arbitration, where they charge an administration fee, which can be rather high. So the maritime community said basically that we don't want this kind of procedure in our arbitration. We want a simpler procedure. We want something that is not quite ad hoc, but not institutional. So as a result of that, the SCMA was formed, and the SCMA offers what we call a self-administered arbitration model, which is like a hybrid between ad hoc and institutional arbitration. It's ad hoc in the sense that the Secretariat does not get involved in the conduct of the proceedings. It does not get involved in the scrutiny of the award, and its fees are very reasonable, right? So in that sense, it is ad hoc, but it's still institutional because there is a framework. There are rules that apply. So if you go for SCMA arbitration, you need to adopt the SCMA rules. So the SCMA rules, they are designed along LMA rules, but with some modifications. So these rules will apply from the time that you start the arbitration until the award is made. And there is specific rules govern each step of the process and also provide for the tribunal's powers to act. And the good thing about the SCMA rules is that there is also an expedited procedure that's available. So this expedited procedure applies for disputes up to US $300,000. But the parties can opt to agree to adopt the expedited procedure, even if the disputes are of higher sum. And sometimes parties do that, or the parties agree to have it on a documents-only basis to expedite the process. And the thing about the expedited procedure is that the timelines are shorter under the rules for you to submit your case statement, defense, etc. And the award must be rendered within 21 days of the last submission that goes in. So typically within 3, 4, sometimes 5 months, you will get an award. So it's a very fast process. And that's the advantage of the SCMA rules. But again, that's something that the community wanted. And we have that in place in Singapore. And now we're seeing increasingly more maritime arbitrations going towards SCMA. And lastly, of course, there is a panel of arbitrators, specialists, maritime or shipping arbitrators who either come from industry or are lawyers with the relevant expertise in that sector. Right. So for the next part of this presentation onward, I will ask my colleague Avinash, who has got experience with construction and project, and to take it forward. Thank you.
Thank you, Jainil. Good evening, everyone. It's very nice to be speaking to you this evening. It's a pleasure to be here in Chennai. I'm just going to carry on from what Jainil was discussing. So he had left you, I think, with talking about sector-specific arbitration. And one sector in which arbitration is particularly important is the construction and projects sector. Fundamentally, that's because, putting aside the amounts of money at stake and the nature, the capital-intensive nature of such projects, the reason why it's so important is because you really need a specialist to deal with a construction dispute. Let me explain why. And perhaps in these terms might be particularly interesting to you. There was a study done on judges. And this was in the context of judges making decisions in respect of criminals who are pleading guilty to their crimes. And the question that the researchers were doing were they were asking themselves, how do judges react to sentencing depending on what they were eating? Okay, what they were eating. And it was found that when the judges had eaten, they were more forgiving. So the criminals who got the best sentences were the ones who were sentenced just after lunch or just before breakfast. Okay. Now that's I tell you that story because the point it illustrates is that judges are human beings. Now, all human beings are fallible and all human beings get tired. If a person is not a specialist in something, most judges are highly intelligent individuals. If you're not a specialist in something, though, the problem is when you have to decide something you're not familiar with, you take a long time to educate yourself about that subject matter. Now, in something like a construction dispute where it gets very complicated, if a lot of time is spent and energy is spent in learning about the subject matter, then the effort that you take to do that is going to eat up your energy in terms of deciding the bit that is really important to the parties. So this reason, what I've just said applies to all that Jainil said, and this is one of the great advantages of arbitration. With a good arbitral institution, what a good arbitral institution does is it selects an arbitrator that knows the subject matter very, very well. So in a construction dispute, and construction disputes are very close to my heart. As it says on the slide, I'm an accredited specialist in construction law. But in a construction dispute, having an arbitrator whom you don't need to explain things like a critical path analysis to is a tremendous advantage. Now, I'm going to move on to the key concepts in arbitration. And the first thing I want to talk about is something called the law of the seat of arbitration. Now, what is that? Now, if you think about it, ultimately, what is arbitration about? It is a mechanism that prevents the parties from going to court, right? It stops the parties from going to court. But an arbitration cannot exist independent of any judicial or legal system, right? Because ultimately, the reason parties go to arbitration is because they have a dispute, a claim, and at the end of the claim, you need a result, and you need to be able to take that result and go somewhere and get someone to enforce it so you actually get paid, right? Otherwise, there's no point to doing it. The law of the seat is fundamentally important because it operates as a bridge between the agreement to arbitrate and the powers of the judicial and legal systems around the world, so that whatever you have consented to in the arbitration for an arbitrator to decide something has effect, has legal status. The seat is the key concept in doing that, the seat of the arbitration. Now, what it does is it first determines the procedural law of the arbitration. The second thing it does is it designates the courts. Thank you. It designates the courts which have something called supervisory jurisdiction over the arbitration. Now, the courts that have supervisory jurisdiction, what they do is they fill in holes or gaps in relation to the arbitration, which means that the arbitration can get to a conclusion. So say, for example, the parties are unable to agree on an arbitrator, and the mechanism for agreeing to the arbitrator doesn't provide a result, say there's no arbitral institution that is designated by the parties. The supervisory courts will then appoint the arbitrator if the parties cannot agree. Similarly, if there is a challenge to the arbitrators because one party says they are impartial, the supervisory court provides an avenue for that challenge. Supervisory courts deal with interim measures, and supervisory courts deal with challenges to awards. The third point with respect to the law of the seat is it determines the nationality of the award for the purposes of enforcement. Now, why is that important? Like I said, the seat is the thing that bridges the parties' consent to arbitration to the coercive powers of the courts. Jainil mentioned the New York Convention on Enforcement of Arbitral Awards. In order to take the benefit of the New York Convention, your award needs to be seated. The law of the seat must be a convention country for it to take effect. Now, the law of the seat is not about the physical place where the hearings are held. You can have an arbitration seated in Singapore, but the hearings are entirely in India. No problem. The law of the seat doesn't have to be Indian law. You can have an Indian law, you can have a contract governed by Indian law. So something that if you'll be more familiar with, but the law of the seat can be Singapore. That's not a problem at all. And the legal seat does not determine the governing law of the arbitration clause. So even the arbitration clause, there's a question as to what law the arbitration clause is governed by. Generally, the law of the seat does not automatically apply as the law of the arbitration agreement itself. Now, what should you think about when you're choosing a seat for arbitration? Now, the main considerations that are usually considered by parties are first, whether the jurisdiction is arbitration friendly, whether it's supportive of arbitration, or whether it interferes in the arbitration process. The second thing is you look for neutrality. Usually, you do not pick a seat in a country where there are two international parties. You tend to look to a third country. The third, geographic convenience, is a lesser consideration. But of course, if you pick a seat that is halfway or 3/4 of the way around the globe away from you, or halfway around the world from you, that might make things a little complicated when it comes to the supervisory courts or the interaction with the supervisory courts. So the common seats for international arbitration are London, Singapore, Paris, Stockholm, New York, Hong Kong. There are many others as well. But these, I think the ones that are identified there will be considered to be the main ones. Now, another key concept that underpins arbitration, it's something I alluded to earlier. It is this: if someone who is party to an arbitration agreement, where there's a dispute, if that person goes to a court, the effect of the arbitration agreement is that the court must stay the proceedings that have been brought, so that the proceedings in court do not move forward and the proceedings instead get resolved in arbitration. That is essential to protecting the integrity of the arbitration agreement. Now, in Singapore, we have two different statutes that provide for which govern arbitration. There is something called the Arbitration Act, which applies only to arbitrations agreed to between domestic parties. But for international arbitration, we have a separate regime. It's called the International Arbitration Act. And that act says that if a party brings court proceedings in breach of an arbitration clause, then those proceedings must be stayed automatically, unless there is some problem with the arbitration clause, or unless one party has waived its rights under the arbitration clause, basically. Now, one other concept that is worth discussing is the concept of ad hoc arbitration versus institutional arbitration. Ad hoc arbitration, rather the best way of illustrating it is this. Institutional arbitration is where the arbitration is managed by an arbitral institution. The key benefit of the arbitral institution managing the arbitration is it helps fill in the gaps between the parties. So let's say, for example, the parties are unable to agree on an arbitrator. It is the arbitral institution that would usually, in those circumstances, appoint the arbitrator. So what I was talking about earlier, the benefit of arbitration in terms of the specialization of arbitrators, it is necessary to have a good institution in order to enjoy that benefit. You see, because otherwise, who's going to appoint it? You don't know whether the person who's otherwise going to appoint will appoint someone with the necessary expertise. Now, institutional arbitrations carry another benefit. They often control the costs of the arbitration as well. So the SIAC, for example, has a scale of fees, and that scale of fees will tell you what the average cost for arbitrations of a particular value are, and it will also tell you what the maximum fees payable to the arbitrators are. And you can see all this just by looking online. There is, in fact, a fee calculator on the SIAC website. There are many other arbitral institutions who have similar information as well. Another key concept is that of the finality of the arbitral award. Now, the parties usually agree that the award will be final and binding, and that's usually the case with almost all arbitrations. However, the losing party does have certain rights. Now, what you cannot do is you cannot appeal against an arbitration award. Okay, you cannot appeal an award in the same way you can appeal a judgment in court. You cannot say that the arbitrator got the law wrong or made a mistake on the facts. You can only challenge an award for very narrow reasons. Most of those reasons are because the arbitrator didn't behave fairly in hearing the parties' cases. Okay? There was some procedural defect in relation to how the arbitrator conducted the case. The second is if the arbitrator decides something which he didn't have the power to decide. So say, for example, the parties to a construction contract agree to have their disputes resolved, and one of the parties then brings a claim in respect of another contract to do with some shipment of goods somewhere else in the world that has nothing to do with that construction contract. If the arbitrator decides something like that, that kind of award cannot be enforced because the arbitrator didn't have the jurisdiction to make such a decision. The other ground, which I'll just highlight to you, is that the award, if the award violates the state's public policy, that is a ground. However, most of the pro-arbitration jurisdictions have taken a very narrow interpretation of the concept of public policy. Now, in the slides that you have, you will see that there is some discussion of the characteristics of the SIAC rules. I'm going to go through them very, very quickly, because some of it, I think, is going to be of particular interest. The first is this concept of early dismissal. So the SIAC rules contain a provision for early dismissal. What that means is that a party can apply and say to the arbitrator, look, you shouldn't go through a full arbitration process for this claim or defense because it is so it is manifestly without merit, and therefore the best thing for the tribunal to do is to make a decision on the question of whether it's manifestly without merit, so that the proceedings can be brought to an end quickly. That is a procedure that is commonly deployed in certain types of cases, particularly where one party is a very, very weak case. So an arbitration that would otherwise take a year to conclusion can then be concluded within 4 or 5 months instead. Other features of the SIAC rules are things like consolidations, where there are a number of different arbitration proceedings. There are also provisions with respect to where there are multiple contracts. There is something called the emergency arbitrator under the SIAC rules. And what an emergency arbitrator can do is this. Now, if you think about it, with arbitration, you need a tribunal to be appointed, right? Now, that process of appointing a tribunal can sometimes take a bit of time. Sometimes, though, you need emergency interim relief. You need an injunction very quickly. The emergency arbitrator is an arbitrator that is appointed by the SIAC on an emergency basis. So the appointment usually happens within 48 hours. The arbitrator then decides in a matter of weeks on the application for an interim injunction. If an injunction is granted, that injunction only has power, and it carries on, but once the tribunal is actually appointed, that tribunal can set aside or deal with that order as it sees fit. I'll just highlight one last thing about this and move on because I'm conscious of the time. One other key feature of the SIAC rules is something called the expedited procedure. The basic concept underlying the expedited procedure is this. If a claim is below a particular monetary threshold, and you can see that the current threshold is $6 million, Singapore dollars, the arbitration must be concluded. That is, an award must be issued within 6 months of the tribunal being appointed. So consider that. You file a claim, the SIAC appoints the arbitrator, 6 months later, you have an award. And that is a final and binding award that cannot be appealed. It can only be challenged on very narrow grounds. It has been an incredibly popular device under the SIAC rules. Now, the SIAC are putting together some draft rules which will apply in the future. They're considering some changes to the rules, including matters such as increasing the threshold of the expedited procedure from 6 million Singapore dollars to 10 million Singapore dollars. And that's because of how effective the expedited procedure has been. I won't go through all the proposed changes, but I'll leave that to your reading pleasure. So I'd be happy to field any questions on those changes if you do have them. Lastly, I'm just going to spend a few minutes on this, some tips with respect to drafting an effective arbitration clause. Now, the arbitration clause is incredibly important because arbitration is about consent. The clause is the expression of that consent. If there is a problem with the clause, you're not going to be able to draw that consent from anywhere else. So it is imperative that the clause is effective, that you get it right. Now, the two key elements are the clause must provide for an agreement to submit disputes to arbitration. And the second thing is it must provide for the seat of the arbitration. With those two elements, an arbitration clause will generally be effective. However, usually the parties provide more. First, you usually specify a set of procedural rules. Second, you usually specify the number of arbitrators that you want and how they are to be appointed. The third is you usually specify things like the language of the arbitration. Now, just some points to consider. One is you should avoid ambiguity, use mandatory language. It's very important to designate the law of the seat, and it is highly desirable to specify procedural rules. I won't go into the point about the law of the arbitration agreement because it is quite an involved point, but I will talk briefly about considerations when choosing an arbitration institution in the context of where you have decided that it is worth using an arbitral institution. And I should say I am a firm believer in arbitral institutions. I do not think ad hoc arbitration, while there is a perception that it is cheaper, it actually turns out to be more expensive in the long run because it results in a lot of delay. There are usually a lot of complications, and that tends to eat up and use up a lot of cost time, and therefore that creates more costs, the complications, and the delay. So I would strongly recommend institutional arbitration almost every time. As to who you choose, that really depends on things like the specifics of the rules that the arbitral institution has, the extent of the supervision that the institution has over the arbitral process, and matters such as the fee structure and the location of the secretariat. One thing I will highlight from this particular slide is the importance of ensuring that the clause is not pathological. Now, most pro-arbitration jurisdictions will try and uphold an agreement of the parties to arbitrate, even if there are gaps in the agreement. What even the most pro-arbitration jurisdiction cannot do is make an agreement for the parties. It cannot substitute its own agreement for the parties' agreement. And that's particularly important because if the clause contains inconsistencies, contradictions, then the C court or a court cannot cure that. So you can see there is an example here. You see, it says any dispute arising from or relating to these terms or any contract made hereunder shall, unless resolved between us, be referred to arbitration under the arbitration rules of the relevant institution or any other organization that both parties agree to. Now here, there's a huge problem because which is the relevant institution? We don't know, which means that the clause cannot be perfected unless the parties agree. Now, once the parties are in a dispute, they're not going to agree to anything, right? So a clause like this is not going to be effective because the court cannot fill in the gap that is left behind by the parties. So it's very tempting often to think that you can negotiate these little things in an arbitration clause. The general thing is that shouldn't be the subject of negotiation. Actually, the best thing is usually to use the standard clause that is provided by the arbitral institution. That is a very clear way of indicating exactly what the parties have consented to. Now, institutions like the ICC and the SIAC have model clauses. You can see them on the internet. You can take them and copy and paste. Best, don't change anything. But the best thing is you can just copy and paste it into your contract. That will 99.999% of the time, there won't be any problem. If there is a problem, it's not because of the clause, it's because there's some court that is taking a slightly different view of things than orthodoxy would suggest. And with that, I am going to stop and we shall move on to the panel discussion. Thank you. Sorry. Yeah. So I have with me the four gentlemen who have been introduced to Bala, Jainil, Srikanth, and Ganesh. I'm going to begin by asking Ganesh this question. Now, Ganesh, we have spoken about how arbitration proceedings are supposed to be faster than court proceedings. But can I ask you, as a person who has significant experience in international arbitration, as well as arbitration in India, as well as court experience of court proceedings in India, how long do international arbitrations take? And secondly, are they truly quicker than court proceedings?
Thank you, Avinash. Firstly, before I start, as litigators, we've been sitting on stage for some time and, watching everybody speak. Firstly, thanks to MMA, Captain Vijay Kumar, Group Captain Vijay Kumar for this wonderful opportunity, and to Rajah Tann, Jainil, Avinash and Bala and Srikanth. It's great to be speaking to this audience. Of course, before I answer this question, there's just one point I want to clarify. Mr. Vijay Kumar was mentioning about the arbitration he was doing on a daily basis when there is, some kind of a feud between, the kids and all that at home. Since we have a varied audience here, I see a lot of practitioners from the Madras High Court, say a very seasoned former in-house counsel and now a practitioner, Mr. Venkatesh, and good friend, who was one of the top in-house general counsels earlier of VFS and many other companies. But there are also a lot of students and others. So I thought this thing I'll clarify because there's always a doubt in the mind as to what exactly this arbitral process entails. What we are talking about, trying to negotiate and settle is more called a mediation or a conciliation. Now, under the Arbitration Act, though we have the word conciliation, we have a mediation act, and it's now become almost synonymous. There we try and settle the dispute between the parties without a binding decision. The mediator doesn't give a binding decision. Whereas in an arbitration, it is almost akin to a civil suit in a private setting. So you go through the entire process, right from the notice of arbitration to the pleadings and then evidence, and you have a hearing unless it's a documents-only arbitration, and the arbitrator makes his decision, his or her decision. The judgment in an arbitration is called an arbitral award. So they make an award and it's enforceable not just in India, but across several countries, more than 150 plus countries, because of an international convention, which Jainil referred to, which is the Convention on Recognition of Foreign Awards, called the New York Convention. So I thought I will give this prelude so that arbitration is a full-fledged process. Now, that begs the question as to what Avinash asked me just now. How much time does it take? So here, when Honorable Justice Ramasubramanian was speaking to us, he was referring to the White Industries case, though of course it's in the context of investment treaty arbitration. The basis on which the India, in fact, did not succeed in that matter was because of the delay that was there in the court proceedings. But now when it comes to an arbitration, when a client comes to us, the first thing everybody wants to know here, all of you will agree with me that the first question on anybody's mind is how much time is this entire process going to take? And how much is it going to cost? So these are the two questions that everybody has on them. And when it comes to costs, mention that in brief before I go on to the time. Arbitration traditionally was believed to be a cost-efficient process, but now there are complaints that it has become as expensive or more expensive as litigation. In fact, just to give you a basic anecdote so that we are all, in terms with what the legal costs are today. One client just walked into one of the lawyer's office, maybe like Avinash, let's say, is a swanky office in Bombay. And he's here and he goes into the office and the client looks at the office. It's so swanky and he's so afraid. I mean, if I'm going to engage this guy, how much should I pay him? So the first question the client asks him is, what is going to be your fees? So this lawyer answers him to his first question as to what the fees is going to be. He says, 1 lakh for 3 questions. The second question he asks is, don't you think this is exorbitant and atrocious? Just for 3 questions, you're charging me 1 lakh of rupees. He says, that could be the case, but let me know what your third question is. So, ladies and gentlemen, that is actually true today. We are thinking and we are sitting here, we are all lawyers. I think we should be conscious about the fact that alternate dispute resolution, parties traditionally were resorting to this because of cost efficiency and hoping it will be in a time-bound manner. But coming to the timeline now very quickly, fortunately, we have an amendment made to the Arbitration Conciliation Act in India with the introduction of Section 29A, where an arbitral award in an arbitration which is domestic has to be made within 12 months after the close of pleadings. For pleadings, we have 6 months' time under the Arbitration Act. And after that 6 months, you have 12 months for the arbitral award to be made, unless parties by consent extend this time by up to 6 more months. Beyond that, you need to go to court to get an extension of time. So that, Avinash, I can tell you for arbitrations, now it's a great boon. And when we all started practice, many years ago in India, arbitration used to be fun for juniors because you just went, had, good meal, and then it would go on forever, on and on and on. But now it's not the case. Arbitrations are finishing, domestic arbitrations are finishing within a year, year and a half. And insofar as international arbitration seated in India, while 29A, when it was first introduced in 2015, had this provision also apply to international arbitrations. But after a lot of hue and cry, because it was quite tight for some of the huge, contracts and big ticket international arbitration. So now international arbitration in India, seated in India, are excluded from the purview of 29A. It's just that they need to endeavor to make the award within 12 months after close of pleadings. But I would say that on an average, it takes about two years in international, unless it's very, very, very complicated. So I think definitely I feel Section 29A is a great boon, and things are moving very swiftly for arbitration. It's perhaps the best thing that could have happened for Indian arbitration in recent times.
Thanks, Ganesh. Jainil, maybe if I could now turn to you. And perhaps just to ask you a question on the scope of challenging an arbitration award. As a matter of practice, because I think we went through some of the material about the grounds upon which an arbitration award can be challenged. But it's one thing to look at those grounds. It's another thing to talk about the actual practice of it. So perhaps you could talk to us about that.
Right. Thanks, Avinash. Right. The short answer is that for a Singapore seated arbitration, there are very limited avenues to set aside the award. For one, you cannot appeal on the merits of the award. In other words, you can't tell the Singapore court that, there's an error of law, an error of fact, and therefore the tribunal got it wrong. Please set aside the award. That is clearly not a ground in which you can rely on. So you can only set aside the award if you bring your case within one of the specific grounds that have been spelled out in the International Arbitration Act that would entitle you to set aside the award. So in that sense, the Singapore courts are very pro-arbitration. And basically what the court says is that, look, if you have agreed to go to arbitration, then you must accept the judgment of the tribunal, even if it is incorrect. We will not interfere. And we will only interfere if a very clear case has been made out that there is a legitimate grounds of challenge. And I think Avinash had already touched on these grounds earlier, right? They're very limited. They're limited to cases where there is no jurisdiction, excess of jurisdiction, where there's been a breach of natural justice, meaning to say a party has not been given a fair opportunity to be heard. But even in that situation, where you can demonstrate that you have not been given a fair opportunity to be heard, you must still show actual prejudice, meaning to say that you must show that if the tribunal had given you that opportunity to be heard and had taken in your submissions, there is a reasonable chance that it would have led to a different conclusion. So in other words, if you were not heard on something that was inconsequential or not very relevant and would not have affected the tribunal's decision, then even though you can say technically there's a breach of natural justice, it's not a ground to set aside the award under Singapore law. And lastly, public policy. Why I say public policy is because in some national courts, they take a wider definition of what is public policy. And even an error of law, right, can be regarded as a breach of public policy. But in Singapore, public policy is very narrowly defined. It's defined as such that, it must be something that is either immoral, illegal, or shocks the conscience. For example, where there has been fraud in obtaining the award, where there's evidence of bribery, right? Where the contract is for an illegal or immoral purpose. So in these situations, the court will say, okay, the ground of challenge is made out and we will set aside the award. So most challenges in Singapore will fail.
Thanks, Jainil. Srikanth, can I turn to you?
Sure.
And this is a question from the audience, in fact. Could you elaborate on the challenges and strategies for enforcing foreign arbitration awards in India? That's really the question. And it sort of follows on from what Jainil was talking about. And so if you could.
Yeah, perhaps I just touch upon the methodology that's carrying on from what Jainil said, as far as challenging arbitral awards in the context of India before I answer the question. Much as Jainil elaborated in the context of Singapore, you will find that in India too, because it is what is known as a model law country, the references to the UN Convention, which Jainil had made in the presentation earlier, India follows very similar standards in respect of what are the grounds for challenging an award are. And they are extremely limited again. Now, Jainil touched upon the usual challenges that flow from natural justice violations and so on. And then he clearly stated that the award will not be challengeable on merits or a mere misapplication of the law. Those standards very much are followed in India as well with respect to India-seated arbitrations. The other quick point that Jainil made was with respect to public policy. The only distinction I would like to draw with respect to how the public policy ground in India is enforced, as opposed to, say, Singapore, is that there seems to be a slightly wider interpretation that is generally entertained by the courts. And that said, there have been a series of cases that have actually allowed for the jurisprudence to be standardized. But here I must make a distinction. It's possible for an India-seated arbitration to be an international arbitration where the parties are, you have parties which are not necessarily domestic. And you could also very much have an India-seated arbitration to be completely domestic. In the context of international arbitrations which are seated in India, you don't have the ground of challenging the award on account of patent illegality on the face of the award. Whereas for domestic arbitrations which are seated in India, patent illegality is certainly a ground, but again, that does not extend to a situation where you're merely challenging the misapplication of the law. It has to be something way beyond that. I'm not sure if I answered the question yet, but could you repeat the audience question? So I want to make sure I get that.
Yeah.
Yeah, so foreign awards in the context of enforcement in India is, as was referred to earlier, India is a party to the New York Convention. And therefore, so long as the foreign award follows certain basic principles, A, it was in pursuance of a valid arbitral agreement. It was between persons, regardless of what the domicile is, what their residency status is. So long as the award was seated in one of the NYC member nations, and it was actually made in pursuance of a valid arbitration agreement, it is recognizable in India for the purposes of enforcement, which means to say that India would need to give it the necessary recognition. And I forgot to mention one more criterion which India specifically requires is that it has to be in respect of a commercial dispute. So long as all of these criteria are fulfilled, the Indian courts will allow for a foreign arbitration award to be enforced as though it were an order of the Indian court. Of course, there are certain procedures that need to be fulfilled before that, but I don't think we need to get into those specific details right now.
Thank you very much. One of the benefits of arbitration is confidentiality. I think that is one of the points that was discussed earlier. And I just wanted to ask you, Bala, now, what should parties bear in mind in considering this confidentiality as a facet to international arbitration?
Right. So the starting point in many jurisdictions is that confidentiality is reflected in the Arbitration Act of the country, for example, in Hong Kong. You may find it surprising, but in Singapore, the statute does not provide for confidentiality within the Arbitration Act. Instead, it's a creature of what we call common law. That means it's implied in our laws that arbitration proceedings will be kept confidential, and that implied, the implication of law has consistently been followed. So, but if there's any discomfort in leaving that question unexpressed in say, the statute governing arbitrations in the jurisdiction. Obviously, you can have a clause within the contract which provides for confidentiality, just to give you comfort. But most of the institutions such as ICC and the SIAC and the SCMA, which Jainil talked about, all of them have got express provisions within the institutional rules, which says that all arbitration matters in the arbitration will be considered confidential. So much so that the documents used in the arbitration cannot be divulged. And if you take a ancillary court proceeding, whether in Singapore, Hong Kong, and so forth, even the parties' names are redacted and they're given alphabetical names such as ABC versus DEF, so that you do not know who the parties are. And if the business that they are in is particularly unique, and you would be able to figure out who the parties are from the business transactions described in the judgment, that also sometimes they change the nature of the business so that there's complete confidentiality, even if the matter goes to court. Yeah.
Thanks, Bala. Maybe Ganesh, I could turn to you because Bala was obviously speaking of the Singapore position. Maybe I can ask you to elaborate on the Indian position.
Yeah. In India, confidentiality of arbitration is now provided in the Arbitration Act. In the 2019 amendments, they've introduced a new section 42A. But the way it is worded at the moment is a little, I don't think it really, in my view, really helps, because it says the arbitrator, the arbitral institution, and the parties shall keep the arbitral proceedings confidential except for implementation or enforcement of the award. So what happens when we, take any other proceedings in court, or, any other application in relation to the award, or for example, even to file a set-aside application. So those things aren't covered. In fact, these are suggestions that have been given by a committee which are looking at the amendments to the Act, that it needs to be quite tight. But that said, though this amendment was made in 2019, in my view, confidentiality of arbitral proceedings in India is a myth. In fact, if you go to some of the popular arbitral, venues where hearings are conducted, you have something like a court cost list with the names of the parties and which room the arbitration is being held. So I think with time, maybe this provision will work, and it has to be tweaked a bit. Like in Singapore, though you don't have a specific provision for the arbitration proceedings, you do have for court proceedings where it can be redacted. So you will see ABC versus XYZ and so on and so forth. So, but that, I think it's very tough for us to do it in India at the moment. Once it goes to the court regime, it's going to be in the public domain.
Thank you. Jainil, do you want to add to that?
Yeah, so just to tag on to the point that Ganesh made, right? In Singapore, if you have court, arbitration-related court proceedings, for example, if you have an application to set aside an arbitration award, right? There are specific provisions in the International Arbitration Act, sections 22 and 23, where the court has a specific power to grant privacy orders. And I believe that's not the position in India, as what Ganesh has said. So this is where Singapore is different, right? So under the provisions of the International Arbitration Act, the court-related proceedings are by default heard in private. So that's the starting point, unless the court otherwise. So in other words, the court can, on the application of a party, say that the proceedings will not be held in private. We will not grant the usual privacy orders, such as redacting the names of the parties, sealing the court file, etc. Right? And our judgment will not be anonymized. So, in other words, the right to privacy, although prescribed by the statute, is not absolute. But the party that wants to lift the cloak of privacy must show that, for example, the award is in the public domain, the award has been published, everybody knows about it. So what privacy is there to protect?
Thanks, Jainil. Now, I think there's a question from the audience, which I think pulls a number of the strands that we've been talking about together. And the question is this: how can businesses leverage international arbitration to mitigate risk in cross-border transactions and protect their interests effectively? And maybe I will begin by asking Bala to comment in response to that question.
So the seat in which your arbitration takes place will of course be the most important thing, because if your arbitration takes place in a jurisdiction that is a New York Convention jurisdiction, then the award that you have can be enforced relatively easily in over 130 countries. So even if the domicile of the defendant or the person who, the party that lost the arbitration, you're unable to enforce it in that particular jurisdiction because maybe he delays the enforcement there because he's got certain influence, you would be able to have 129 other jurisdictions where he may have assets or his cash may flow through that you can attach. So you can mitigate the risk by choosing a place of arbitration which allows you maximum capability to enforce the award in numerous jurisdictions. So that'll be one way to mitigate.
Okay, I don't know whether
Yeah, just to add on quickly, another point, choose a good arbitrator. Right? Because as we spoke about finality of awards, right? If the arbitrator or the tribunal gets it wrong, then that's too bad for you. So you want to mitigate the risk, make sure you choose the good arbitrator, a good arbitrator who has the specialized knowledge or the legal knowledge that is required to understand the case and to arrive at the right decision.
So, we talk about choosing the arbitrator, but let's be clear on exactly what it is we're talking about. If an arbitration clause provides for the appointment of 3 arbitrators, then as one party, you have the right to choose one arbitrator, the other party has the right to choose another arbitrator, and those 2 arbitrators then would usually appoint the 3rd arbitrator, and if they can't agree, there should be some way of resolving for that. But, I was speaking earlier about the difference between institutional arbitration and ad hoc arbitration. And a question is coming from the audience about what are the key differences between institutional arbitration and ad hoc arbitration, and how should parties decide which approach to take, which is cost-effective and the best option. Now, Srikanth, I wonder whether I might turn to you as the arbitrator or the person whose main practice is as an arbitrator. From your perspective, the difference between institutional and ad hoc, why it's important, why it matters, and the key differences, and how should parties decide?
I mean, I think a lot of it is actually down to the existing culture, right? I think we need to address the point that in India, broadly speaking, ad hoc arbitration still holds sway. And it's been quite an uphill task for institutions to break into that. And I think a lot of it is down to perception. While there has been a slight uptick in the number of institutional arbitrations within the country, I think the perception somewhere lies that when you have an ad hoc arbitration, the parties seem to be more in control of various aspects of the arbitration, right from appointing the arbitrator to potentially the costs involved and so on. Now, I say that because I think we need to recognize that this perception exists. But at the same time, I think experience internationally as well as more recent experience with institutions in the country will tell us that that's not necessarily the case. The pool of arbitrators that are empaneled with the institutions is vast, it is diverse. You have a number of experts and you have a number of retired judges too, which seems to be the preference in India with ad hoc arbitrations, who are part of these institutions and they're empaneled with these institutions. So on the point about the parties having more control over the choice of arbitrator, I think certainly that's no longer the case, that it's better off in ad hoc. When it comes to the question of costs, again, while parties feel that it is going to be more efficient for them in an ad hoc proceeding, it's not necessarily the case, because many institutions do have some sort of, I wouldn't say control, but they do have some sort of an upfront schedule which tells parties exactly what the cost of the arbitration is going to be. And you mentioned this in the course of your presentation as well, where you can go up onto the website of, say, SIAC or potentially one of the others, and you're able to calculate exactly what the cost of the arbitration is likely to be, at least in the range, before you jump headlong into that. I think the one other point that distinguishes institutional arbitration from ad hoc, and I think I see that as a huge benefit. And again, maybe I should temper that, but at least I see it as a huge benefit, is some of the institutions do have a process of scrutinizing the award, right? Now, I understand that that's not something which parties understand completely, but I think it's important to address the point, which is that the institutions don't get involved in the actual decision-making at any stage whatsoever. The arbitrator, the tribunal which has been chosen, has complete control over what the decision is. But what the institutions try to do is to ensure that from the perspective of any egregious mistake or a calculation error, etc., it's brought to the notice of the tribunal or the arbitrator so that they have the opportunity to correct it before the award is released. And then it becomes challengeable, you see, on those grounds. So it's more about ensuring there's a basic level of control that is exercised in ensuring the quality of the award. Nothing more, nothing less.
Thanks. Ganesh, there is a question from the audience that is directed specifically at you.
Oh my God.
And it's such a good question that I have to ask you. Can the scope to appeal an award or a consent order, but let's stick to an award. Can the scope to appeal an award be widened by not keeping it just to coercion, fraud, and misrepresentation?
Repeat, sorry.
Can the scope to appeal an award be widened by not keeping it just to coercion, fraud, and misrepresentation?
Okay, first and foremost, we can't appeal an award. What we can do is to file an application to set aside an award on extremely limited grounds under Section 34 of our Act with arbitrations seated in India. And you can resist enforcement of a foreign arbitral award on similar grounds under Section 48. But there's only one subtle difference. When it's a domestic arbitration, you can also challenge it on a ground of patent illegality. So in India, what we do, though we don't have an appeal on a question of law like in England under the English Arbitration Act, or in Singapore under the Domestic Arbitration Act in Singapore. Singapore has two enactments. International, it has International Arbitration Act. For the domestic arbitration, there is a separate act called the Arbitration Act. Under the Arbitration Act, you can appeal on a question of law. In India, though we don't have a provision for appealing on a question of law or a general appeal, a lot of these issues of egregious errors that Srikanth was referring to is brought under patent illegality, which is still kept. It was the patent illegality concept was introduced in the ONGC and SAW pipes case, where you could bring these things. But if you look at fraud and other aspects, one issue of fraud is it goes to the question of arbitrability itself. So if there's an issue of fraud, you need to perhaps challenge arbitrability. There's a Supreme Court judgment in Ayasami versus Paramasivam, where the Supreme Court has made a distinction between mere allegations of fraud and serious allegations of fraud. If it's mere allegations of fraud, the Supreme Court has said that it is arbitrable because any reluctant respondent can allege fraud. The serious allegation of fraud, and let's say it attracts provisions of the penal code, then of course the tribunal can decide. But at the end of the day, the arbitrator is the master of the proceedings and he has to decide whether it's arbitrable or not. And if the arbitrator does decide, even though it is a fraud issue and it is decided, still you can of course bring it under 34 saying it was beyond his jurisdiction and all that. So you can still challenge it on very limited grounds provided in 34. If you think it's patently illegal, you can still bring it under 34. But I would say it's not going to be a very easy task, considering that the Indian courts now have become very pro-arbitration, and setting aside an award unless it's hilarious violation of any of the provisions of 34 is not going to be easy.
Thanks, Ganesh. Jainil, maybe I'll throw you as well, which sort of follows on from what Ganesh was talking about. What if the parties were to agree as in their arbitration agreement that the courts of the seat shall have the right to appeal, to sit on in appeal on an arbitration award on the application of the parties?
So what you're saying is that the contract specifically provides that you shall have the right,
Can appeal, yeah.
or you can appeal. That would be contrary to the Act in Singapore. Because what the Act says is that you need to rely on one of the specific grounds that as we have mentioned earlier and discussed earlier, to set aside the award. So if you don't satisfy any of those grounds, right, you can't set aside the award.
No, no, in India, there is a case, but of course, it's called Centro Trade, Supreme Court judgment, where they had two-tier arbitration clauses. So you have a first round, and for the second round of appeal, you go to a different institution. But it was challenged saying, how can you do that in an arbitration? But Supreme Court upheld saying it's party autonomy.
Yeah, but you see, you can provide, for example, in your rules, in the arbitral rules, there is a right of an appeal. For example, GAFTA, Grain and Feed Trade Association, right, in the arbitral rules, right, those rules say that if there is, there is an initial tribunal that's constituted, and if a party is dissatisfied, it can appeal to the Board of Appeal. Similarly with Poram, there is an appeal board. So in that situation, yes, right, of course, you can go through that process and you can appeal the award. But once you have a final decision from the Board of Appeal from GAFTA, and you want to come to Singapore to set it aside, then you need to satisfy the act.
Thank you for dealing with those questions so well. And I must say thank you to the audience for all these questions, because they are fantastic. We haven't finished yet. We've got a little bit more time. I do want to turn to a slightly different topic, and more about the practicalities of actually prosecuting an arbitration. And maybe if I could first ask Bala, as a person who has a tremendous amount of experience in shipping maritime disputes, and having done both court litigation, an extensive amount of court litigation, an extensive amount of international arbitration, what do you think the differences are in terms of the advocacy in these two processes?
So while arbitration is adversarial exactly like how it is in the court proceedings, the advocacy in terms of eliciting the facts is a lot more, to use one of a better word, gentle. In court, the cross-examination can be theatrical sometimes, and you can have a very domineering counsel. You can have a counsel that tends to bully the witness. But in the international arbitration setting, quite often, because the arbitrators are selected from forums which are very different from ours meaning Singapore, UK, India, where we had inherited witness in the witness box kind of a setting. In the European culture, it is less adversarial like that. So some of the arbitrators who have had experience sitting with arbitrators from a different culture, particularly the European culture, they do not like domineering questioning tactics. They sometimes take it as a weakness in the case that is being masked by a very arrogant or aggressive advocate. So you will have to read the arbitrators quite carefully when you choose that method of cross-examination. So cultural aspects, you need to be quite attuned, because if you treat it like exactly like a criminal case that you would do in the local courts, it may not bode so well for your client, because certain impressions may be formed by people from different cultures.
Thanks, Bala. Srikanth, I wonder if I might ask you to follow up on that. Again, from your perspective, sitting as arbitrator, what to you is the difference?
I mean, I think Bala touched upon it, but just elaborating. One of the things that in an international context, especially that counsel should be prepared for, is that the arbitrator tends to be extremely familiar with the submissions beforehand, well before the oral submissions begin. And so invariably, the arbitrator would have given a certain set of hints, at least, in terms of where he would like to be specifically addressed, on what issues. And therefore, counsel would do well to pay heed to that and ensure that rather than repeat or have his own set of submissions, try and address what the arbitrator has indicated he or she would like to be addressed on, right? And that's something which to some extent happens in a court of law as well, but more so specifically in international arbitrations, where the tribunal is extremely well prepared before the actual date of the oral submissions.
Thank you, Srikanth. Just to add to this, from my perspective, one of the critical differences, and I think it's manifest particularly in jurisdictions like Malaysia, where I practice, along with Singapore, is the importance that is placed on written advocacy in arbitration. That is, I think, a key takeaway and a key difference with respect to how things are conducted in arbitration proceedings. And that sort of links to the subject of case preparation in arbitration. And maybe, Ganesh, I can ask you to perhaps provide your comments on the importance of case preparation. Even what does case preparation entail in arbitration?
Right. See, I see many of our colleagues here, practice in the High Court, which is mostly appellate jurisdiction. And in India, which is very unique, most of the practice of the High Court lawyers are prerogative writ petitions. Because your mandamus, your arrays, which is not the case in Singapore. In Singapore, very few matters like that go to court, mostly civil actions. But here, majority of the practice at the High Court level is mainly that. And you do have civil side, which is unique to only 5 high courts in India, just Delhi, Bombay, Madras, Calcutta and Himachal Pradesh, where you can directly go to the High Court for a civil suit beyond a certain amount of money. In all the other states, you have to go to the district court or the city civil court as appropriate to file a civil suit. Arbitration is nothing but very similar to a civil suit. And in a civil suit or in an arbitration, you have to be a master of the facts. See, sometimes when we go to lawyers and we say, hey, just a legal issue, natural justice has been violated in this case. Immediately they say, oh, Maneka Gandhi versus Union of India, 19 AR, 1978 Supreme. First, what is the fact? What, according to you, is the natural justice that has been violated? So we need to get to the facts completely thoroughly in an arbitration. You need to know the entire pleadings and the documents clearly, and then you apply the law to that proceeding. I think that is something which I find that here, maybe we are all too busy running around in court, and sometimes we don't have enough time to focus. We need to know the facts thoroughly. If you do that, half the battle is won, right? So when it comes to case preparation, I think that is really, really important to know the facts really well. And of course, then you talk about advocacy. I think Avinash made a very important point that in arbitration, be it in India or even in international arbitrations, most of it is in written advocacy. So you do have to write your pleadings. Everybody wants now a written submission after the trial is over. And unlike in international arbitration, where once your trial for cross, you have a very short closing. But in India, we have a separate few days for your legal arguments. And sometimes you do your written submissions and legal arguments, finish your legal arguments, then give your written submissions. And it's extremely important that we should, focus on these areas for preparation. Facts, extremely important. Of course, law is equally important, but I think from my experience, we miss out a lot on that. We straight jump and not focus too much on the intricacies of documents and facts, which thorough preparation is very much required.
Thank you, Ganesh.
Just to add,
Sure.
just to add to that, I think in the context of what we're now increasingly seeing across, which is expedited arbitrations, this becomes even more important because you don't necessarily have the time to have extended hearings and so on. So when you get into an expedited arbitration, especially because now you see many institutions raising the bar, as Avinash said, in terms of the quantum of the dispute that is covered under that, it becomes all the more important that you focus on the written part of your submissions.
Thank you, Srikanth, because that sort of links directly to the last question that I'm going to pose, and maybe Jainil, I'll ask you to answer it. So it's with regards to expedited procedure specifically. And the question is, how does a practitioner go about presenting their case, researching and examining witnesses within 6 months, especially since construction contracts go for almost thousands of pages, spanning years of communications? Maybe, you can go on, maybe the shipping contract.
A short answer to that, if that is the nature of the dispute, it's not suitable for an expedited procedure.
Well,
But if you want to take it up on an expedited procedure, then you better be prepared.
So yeah.
So that's one thing. Now, arbitration is consensual, right? So actually parties can agree, for example, that we are taking an expedited procedure, right? And we go by documents only. But if one party says, no, I don't agree to documents only because I want to examine the witnesses, the issues can only be properly determined if the witnesses are cross-examined. Then in that situation, the tribunal, unless the rules specifically empower him to do so, will have to have an oral hearing. And then you probably will find it very challenging to get everything done within 6 months.
So I'm just going to jump in here
Yeah.
and say that we just do it. We do it, and we've become very, we know how to run the case now so that we can get it done within that 6-month period. It takes a lot of effort, it takes a lot of planning in advance, and it is intense, but it can be done. And I'm talking about a full case all the way to the end, including an evidential hearing.
Thank you. I think subject is such we can carry on going. But this is only a teaser. We'll bring you more seminars as Justice suggested. We'll have a off-day seminar soon. But more people can come and more interaction can. Ladies and gentlemen, big round of applause to distribute panel this evening. Jainil, Avinash, Ganesh, Srikanth, and Bala. We also thank Justice who could not join us in person. But since he was separate medicine, we made a memento for him. Can I have the online memento, which will be given to Justice? What we do is, on behalf of him, we give to the poor students books and other items, so that because people like him come and speak, that is what brings people here. And may I also request you please step forward and accept a token of our appreciation from MMA. What we are going to give you only some more books, and what we are also going to give you, thing where you have to drink so much of water because you keep talking quite well. Thank you, ladies and gentlemen. Thank you, viewers. We have got over 820 viewers watched it online. Thank you for so many questions. I've only given 50% of the question what we came online. Thanks so much for everything. Thank you, ladies and gentlemen, who joined us this evening. And till we meet again, bye-bye and good night. The speakers are available here for you to interact. Thanks so much.